Hello, my name is Riley Berry. I'm a final year JD student at ANU, and I'm here with Professor Mark Nolan for a session of Ask an Academic. Um, so, Mark, how did you come to be an academic?
Halfway through my law degree, I took some time off and did an honours degree in psychology. So I was a science law student. So that was a full year doing research, extra study, different areas of psychology. And I think I got the bug to be an academic and a researcher then. Finished my law degree, did a PhD in psychology, and came back and started teaching law. Along the way, I've done a Masters of Asia Pacific Studies as well, and I love what I do. The elements of it all being research, teaching, and service to the professional communities within the ANU and outside of it. So heavily involved in professional associations, which are interdisciplinary ones between psychology and law.
And how do you find the integration between these two, arguably very different disciplines?
Well, every now and again, I try to combine three things: Asian studies, psychology, and law. There's still resistance from both sides in the psychology and law community. For example, some psychologists who don't really want to understand enough about law, and some lawyers who think they don't need to understand anything other than their understanding of psychology and science. So I think it's a matter of translation between the disciplines, and as an academic working in an interdisciplinary way, that's what you're doing, often translating between those two professional groups or academic groups who really should be able to understand each other's perspective.
What are the areas of law that you focused on in your career?
So at the moment, I'm teaching criminal law and procedure, which is include federal criminal law as well, a law and psychology elective at the law school, and Asian studies more in the sense of comparative criminal law, but some issues of federal criminal law that engage an understanding of Asian cultures and Asian law and Asian politics. So issues to do with human trafficking, for example, and jury reform. Really good example of how criminal law and Asian studies and some psychology all comes together to solve the one problem.
Are there any other kind of new courses that you think would be fun or interesting to develop?
Sure, look, we're really interested to develop sentencing and prison law courses. So I've been heavily involved in our legal literacy program where we take volunteers from the ANU College of Law into the Alexander McConaughey Centre, our local prison, to actually get them to teach law to detainees. So big areas of prison law, human rights and prisons, as well as sentencing law, they're the big areas. I've worked for some time now helping the National Judicial College of Australia have a two-yearly conference on sentencing law, and the lawyers, the judges need it, and I think, in academia we need it. The other bit of teaching I've been doing is in our military discipline law course, and in also that's only for ADF legal officers from the military, but also in the national security space. So some of the electives that we have in national security law, not only about counterterrorism law, but generally about the law that regulates the intelligence industries and agencies, as well as any other technologies or other investigative tools that we use. So I think they're big developing areas to keep on thinking about, researching about, and teaching about.
What do you think are some of the most kind of live topics that are in the news today regarding those issues?
I've been heavily involved in counterterrorism policy and thinking more about what we're going to do with people who have served the entirety of quite long sentences for terrorism offences, either Terrorism Act offences or terrorist organisation offences, or the new offences of being in a declared area, the foreign fighter type offences. So late last year, I was involved in trying to get the right type of regime or brakes upon the regime of continuing detention orders for terrorists. So we don't like to release unrehabilitated sex offenders or violent offenders, but now in the Commonwealth we have this regime of keeping terrorists beyond the end of their sentence if they can't pass tests by psychiatrists, psychologists, GPs, maybe intelligence officers who know that these people are still radicalised and engaged in terrorism-related thinking. So the big controversy at the moment is what to do for the 1, 2 or 3 years that these people might be incarcerated beyond the end of their sentence, whether that's going to be in a supermax facility, whether that's going to be in a separate facility, whether they'll be mixed with remandees or sentenced prisoners. But beyond that, the big issue is, can we predict someone's recidivism risk as a terrorist in the same way as we can for a violent offender or for a sex offender? And I think the psychology is, and the forensic psychiatry is really not there to some extent. So that's a big issue at the moment. Beyond the Commonwealth regime, there's a regime in New South Wales and in South Australia, and you don't have to be incarcerated as a terrorist to fall under that regime of being kept beyond the end of your sentence, because there's a risk that you might be engaged in terrorism. So 3 big regimes in Australia to study at the moment.
Yeah, I've actually done some research on those continuing detention orders in those regimes and the High Risk Terrorist Offenders Act, which was the one you were referring to. The High Court hasn't considered that act for its validity. As far as I'm aware, it hasn't been used yet.
No, but the constitutional authority from Farden and like cases that had upheld the constitutional validity of the sex offender and violent offender schemes was always assumed by Malcolm Turnbull and Brandis as Attorney General at the time as being a non-problematic area of a law. So Turnbull actually was triumphing the Farden decision and saying it'll apply uncontroversially to a federal law that talks about federal offences and incarceration of federal offenders in state prisons beyond the end of their sentence. Some really good work is being done by the Attorney General's Department and the Corrective Services departments around Australia about how to manage these schemes. But we'll wait and see when the first application is made by the Attorney General to keep someone inside beyond the end of their sentence.
Yeah. Sorry, off on a tangent on that. We'll move on to some other things. But I understand that you worked with Japan doing a few different things. Can you tell us a little more about that?
So really early on, there was a colleague here, Kent Anderson, who was a Japanese law specialist. And around the time that Japan had decided to move from having no jury, the last jury was much earlier, pre-war, Japan's criminal justice system had no jury, and then they decided to take a European approach and have a mixed court model where judges and citizens would deliberate together on the same bench, like France and Germany, etc. All the cries from the law reformers at that stage was the Japanese psyche cannot cope with that. There'll be deference to authority, no citizen will want to overrule a judge. And we got a little bit offended by that and thought that maybe this requires a whole lot of empirical research. And thankfully, along the lines of us being interested in this, the Ministry of Justice in Japan funded social psychologists and lawyers and law and society academics to actually study mock trials of Japanese citizens and Japanese judges coming together to deliberate on mock trial questions to refine the rules around all of this. And this scheme's now been running for more than 10 years in Japan with some really good results of citizen engagement. And the judges themselves have actually reduced their anxieties about sitting alongside citizens and making some type of not only verdict on the case, but the sentence as well. So liability and sentence is both handled by this mixed group. Since then, we've had a Korean system, a bit similar, and a Taiwanese system that's about to roll out as well. So I just think it's a great example of Asian societies and law reformers turning to the West, not the American, Australian sort of model of all citizen juries, but to the European model, to see whether those systems will work in Japan and the Asian countries. But we learn so much about our own system by seeing how they adapt and provide a system that's quite different. So on really quite radical afternoons, I feel as though wouldn't it be good to have these mixed court models in Australia rather than just some of the problems and challenges that our all-citizen juries have. So that's been a great area of research for me, and it's now spiralling out throughout Asia.
Yeah. Do you think there's any future in those mixed juries in the American or Australian model? I mean, especially considering the Australian use of juries has declined considerably.
A lot, especially in civil law, unlike what's happening in America. And we have these concerns, don't we, about the sort of democratic deficit. We don't know how well a juror follows instructions. And there's a lot of jury research that colleagues and I are interested in about supporting the deliberative jury. Things called special verdict forms, or they're now called jury question trials. And there you actually give questions to the jury. But we still don't know whether juries are nullifying. We don't get into the secrecy of the jury room to understand what's going on. We're worrying about misbehaving jurors. We're now worrying about actually prosecuting jurors for breaching the Jury Act and things. All of that could be quite different under a mixed jury model. So the other halfway house would be to have a group facilitator in the jury room to actually control the decision making and provide some sort of decision making support. All of these are radical ways in which we could save the jury's reputation. And it's not the easiest thing psychologically for a group of people to do without help, without experience, and on their own, in a sense, trying to remember the trial and remember the jury instructions from the judge. But question trials and other sort of decision support tools are now legislated in Victoria and are a really good starting point for seeing how we can improve the all-citizen jury if we weren't to be as radical and go for a mixed court jury.
Yeah. You've done a tremendous amount of work internationally. Do you think that either working or studying internationally is of benefit to law students?
Oh, absolutely. Some of my greatest experiences are going and working in Japan. I did the Chuo exchange, which is a teaching exchange that we have here, going to Chuo University, an International Centre for Comparative Law there, where I was actually teaching Japanese law students in English. I've done some work under a grant that we got here to go to Myanmar and actually be at University of Yangon and to help HDR supervisors and HDR students to work around their PhD challenges. It's a wonderful chance to sort of work over there. And, you know, if you haven't been into a law school in Myanmar, for example, it's just such a different environment. Everyone's learning in English, everyone's doing masters of research and masters in law before they do a PhD. And the facilities, you know, just getting a law library up and running based on donations, really a different reality to what we see in Australia or American law schools, and that perspective is important. Beyond that, I've got a lot of experience going to Thailand as well and being in the law schools in Chulalongkorn and Thammasat universities to teach there. And again, the entire Thai law curriculum has been translated into English, and they teach Thai law in English, and they teach master's degrees in English, and then they've got their Thai undergraduate and master's courses as well. But for a country and a group of law academics to be bilingual, trilingual enough to be able to do that, it's just an amazing experience to actually be there and to see that done. So teaching, law students are all in Thailand, but only half of them are competent in Thai. They want to learn about the Thai legal system, they do so in English. These opportunities around the world are just amazing.
What do you think are some of the biggest lessons that kind of the Western legal system, which is very different, could learn from the Eastern legal system?
I think it's about being not wedded to tradition, but open to reform. And a lot of these Asian legal systems have had reform suggestions and reform entrepreneurs pushing new models from constitutions through to jury systems, through to correctional systems, let's say. And I think, in a way, we're a little bit more resistant to reform. Also, the reform processes that I learned about in the Japanese jury research show that it was long-term reform, rather than us doing a quick and dirty Law Reform Commission report, which often isn't quick and dirty, but doing something like that and then implementing something quickly or politically, it pales into insignificance when the Japanese took 5 years of empirical research before they were prepared to write the jury law and the jury rules. Those timescales are just amazingly different to what we sometimes do with law reform here.
Yeah. Is there any area that you would like to see Australia embark on to get that empirical knowledge in order to guide law reform?
I think some of the law reform commissions in Australia have included, from my perspective, psychologists and psychological literature into the legal research and the political research that otherwise goes into a law reform commission report. So the scientific evidence base, whether it be psychological, criminological, economic, otherwise, has sometimes really had, in recent times, more of an impact. So what I'd like to see, I've done some great work with the Royal Commission into institutional responses to child sexual abuse. Commissioned as an interdisciplinary academic to do some research on memory and prosecutions of perpetrators of childhood sexual abuse. That's a great model, rather than us trying to get ourselves into those audiences in any other way.
Excellent. Well, I think that's about the time we have. So thank you very much for all of our YouTube Live and Facebook Live viewers, and we'll see you next time with Ask an Academic.